Hey guys, and welcome to the weekly docket. We'll start in Florida, America's crazy case capital, head back out to Indiana, and then to South Carolina. The first case out of Florida is a feel-good story where the litigants in the case got what they wanted. Everyone happy. The prosecution had sought the death penalty against Steve Lorenzo for 2 terrible murders. And he said, hey, if I did these things, I deserve to die, and that's what I want. I want the death penalty. Well, the judge accommodated him and said, you get the death penalty, to which he told the judge thanks, and he really appreciated it, was in a good mood, left the courtroom. Let's listen.
Ti condanno a morte. That translates to, I sentence you, Mr. Lorenzo, to death. That is the punishment that you deserve for these horrific crimes. Thank you all very much.
Thank you, Your Honor. I
And
appreciate it.
Mr. Lorenzo, may God have mercy on your soul.
My soul is fine. Thank you, sir.
You know, you can't go back in time and save the victims, but when there's a trial like this and it can end where everyone's happy, at least that's something. In the sunny state of Florida, which is still, I think, the capital for strange crimes in America, although, you know, Wisconsin is giving them a run for their money, and California is always up there, in New York, but still Florida is a special place for weird crimes. There's the case of Sarah Boone, who shut her boyfriend up in a suitcase. That's real. Then laughed at and mocked him as she videoed him while he's saying he can't get out and he can't breathe. Eventually, she went to sleep while he slowly died. Well, her case is getting ready for trial in April. Her long-running dispute with lawyers assigned to her case, she's been through several, has come to an end, at least for now. Her counsel requested recently and received permission to hire a private investigator to help with the case. At least in early January, though, tensions remained as she wrote again, complaining about the situation and awaiting the day for her to say her truth inside of everything. But no disputes were registered in court minutes from the January status conference, so I think the uneasy truce between lawyer and client appears to be holding for now. Last I heard from Law and Crime, she'd pivoted from it's just an accident, which is not a defense to homicide by reckless conduct, and that's the charge she's facing. So she's gone to the Darrell Brooks School of Ineffective Defense, to, hey, it was self-defense to be supported by battered spouse syndrome. I went over the law on that in Florida in a previous video. It's a little strange. I don't buy her theory, of course, to put it mildly. But hey, she wants to be seen as a victim, and claiming that would help her achieve at least that goal. I think she'd need some expert testimony to support that. I don't know if they've engaged anybody for that or not. So we'll see if she goes to trial in April. I hate to say this pun, but I'm going to say it. It looks like an open and shut case. In Indiana with Richard Allen, who is charged on felony murder counts of the Delphi Bridge murders of Libby and Abby. The apparent next major item up for Allen is his request for bail. That's going to be in June. Let's start with the Indiana Constitution, which says, offenses other than murder or treason shall be bailable by sufficient sureties. Murder or treason shall not be bailable when the proof is evident or the presumption strong. You can find similar language in several states about this proof is evident, presumption strong stuff. And you can see why Allen's attorney said the proof is not evident and the presumption is not strong, because that's the legal standard. It's a term that goes back in this country centuries. But what does it mean? In State v. Fry, 2013, the Indiana Supreme Court said, we hold today that when a defendant charged with murder or treason seeks bail, the burden is on the state, if it seeks to deny bail, to show by a preponderance of the evidence that the proof is evident or the presumption is strong. So the judge hears evidence and thinks he probably did it. That's good enough, no bail. Preponderance just means probably, like a civil case. But if not, then the proceeding moves forward like other cases where the state shows, if they can, that he's a flight risk or danger to others. And the judge can set terms of bail from the person being on their own recognizance to a high dollar bail that they may not even be able to meet, or other terms of release. But in my opinion, the state will meet the burden and he will stay in jail. Again, they just have to convince the judge, he probably did it. But if not, who knows what will happen, though it seems likely a bail would be set, and if Allen is as broke as he says, he might not be able to meet it anyway. However, the bail fight is on in Indiana, like in other states. There's an effort to minimize cash bail, And I get that. There's certainly cases where it's unfairly applied needlessly, and it's just a profit industry in some cases. It's not keeping people from fleeing or protecting the public from risk. I get it. But like anything, you can take it too far, and there have been high-profile cases in Indiana where charity paid bail for defendants, and they went out and murdered people while they were frolicking out on bail. Now, I doubt that impacts the Allen situation, even the blowback from that, where there's a potential amendment to the Constitution in Indiana to change this. But even the lenient Rule 26 they have, which tries to reduce the use of cash bail, it excludes murder defendants, and that's him. Still, that's the landscape we're operating in. So what will happen is they'll have a hearing. The state has to present evidence since they have the burden now, at least enough to convince the judge that Allen, quote unquote, probably did it. He stays in jail if he does, if they do. If not, the judge will review it and see what release terms are appropriate. Still, there'd probably be a bail there, but I just don't think that's going to happen. But the state would have to put on some evidence. Now, are they going to try and keep that super secret or whatever? I guess we'll have to see. Right now, we know their evidence is timeline and the alleged matching of the round found on the ground to his gun, which is obviously going to be subject to dispute. Now down to South Carolina, let's look at the Murdaugh family murders trial. As the week moved on with Murdaugh calling law partners who confirmed his felonious thefts and saying in some cases they never really knew who he was. And one saying when he heard Alec had been shot, he said, "I didn't believe that." On top of the tiny ninja theory and Murdaugh admitting he lied repeatedly to investigators about material facts surrounding the murders of Maggie and Paul, it appears perhaps Murdaugh is going for the Darrell Brooks calling witnesses who actually helped the other side and offering a ridiculous alibi excellence in advocacy award. Let's check out what's been going on. Murdaugh gets on the stand. First thing he does, essentially, after saying he didn't kill his family, is started admitting about all the lying he's done. He admits he's lied to clients who he owed a fiduciary duty. He lied and stole from sick and injured men, women, children, and disabled people. He admits abusing his volunteer solicitor position, using his badge he got as some kind of prop to get law enforcement perks whenever he wanted. He admits arranging his own, he says, botched killing and then lying about that to 911, to police, and to investigators. He admits lying to police multiple times about not having been at the crime scene of the murders of Maggie and Paul at a very relevant time to the investigation, essentially contemporary with the moment their phones were last accessed by them, and they were never heard from again. He checked the bodies of his slain family members, even trying to roll Paul over, which caused his phone to pop out, the old pocket pop. Come on. Which he then placed back on Paul's butt, his dead son, okay. But he didn't get any blood on him. Other people who visited the scene did, but not him. Squeaky clean on the scene of his family's murders. That's not a lot of evidence by itself, but come on. But, he's lied about all these things. Other shootings, lied to police, lied to clients, lied to family, lied to friends, stolen millions and millions of dollars. But believe him now, please. Okay? No, not going to believe him. If he gets off, it won't be because of his word. The alternate theory is the short ninja theory, or T-1000 if it's the little gray man or whatever. But I'm going to stick with ninja for now. And this theory is discussed. The ninja comes to assassinate, but does it at the kennels and not the house where people would normally be. The ninja waits at the kennels until Alec leaves without alerting the dogs, LOL. Come on. And then at most seconds between when Alex arrived back at the soundproof house, he strikes with multiple weapons and the phones are never used again. Or the ninja showed up after Alec left, and we have to believe Maggie and Paul just quit talking to people they were in the middle of conversations with, text and voice, to when Alex left the kennels until when the ninja finally made his deadly assault. Yeah. Okay, well, also that ninja is 5'2" tall, so it couldn't be Murdaugh because he's, now he's 6'4". I thought he was 6', then 6'3", 6'4". He does look about that tall. But asserting the 5'2" height as probable based on the circumstances, it simply being one possibility, that's ridiculous. And also the ninja, according to Internet Galaxy Brains, perhaps picked up a Murdaugh 300 Blackout and used it. Maybe he only came with a shotgun and then picked up this battlefield recovered weapon and used it. So we have a ninja who comes with just one or no weapons and then leaves with both. But this ninja, worn out from carrying all these guns back to the getaway vehicle, couldn't muster the energy to toss the phone out the window across the street and into the soft ground on the other side of the street, and had to park, walk across the street into the woods, drop it, and come back across the street, get in a getaway car, and get away. Now, defenders say Murdaugh was too ungainly to make the smooth moves necessary to fire that 300 blackout. This dude can't bend over or get down on the ground and fire from a knee or something. I mean, he's too tall and fat. But they have no problem believing he was surprisingly sprightly and able to arrive at the scene, get out of his truck, check his wife, check his son with the phone pop, return to the truck, and call 911 in 17 seconds. Yeah. Now, I can respect an observer questioning the state's case. You should. The state has the burden of proof. That's not the same as engaging in wild speculation to exonerate the defendant or not seeing the absurdity of some of these stories. So the case should wrap up soon, maybe a short rebuttal after the defense case. I think Murdaugh won't be on the stand until the rest of today. They got these expensive experts they want to get in. And then we'll have closing arguments, and we will hear the opinion of those who matter, the jury.